Hello and welcome to your #1 legal talk show, The Courthouse. I am Itohan Olomoagbodo. On this show, we get to learn about concepts of the law, the basics of the law, really, and we get to hear about life issues that are addressed by our panel of legal experts. We'll take a quick break and we'll be back. Stay with us.
If we have to give you anything, then we have to give you everything. Love Plus Channel 465 is simply the best. Because we have something for every member of the family. So dads, keep the team spirit going on with our intriguing sport highlights and reviews. And moms, cooking is never boring when you have our intriguing drama series. And for all your lovely kids, just sit and enjoy. This, and oh this. I told you, we have something for everyone. Because we are indeed all about you. So keep it locked on Love Plus Channel 465 on Star Times.
You're welcome back. This is the Courthouse, and this week we'll be talking about wills and codicils. I know you'll probably be hearing about wills, but codicil is a term used to address something that our guest is going to tell us about this week. But generally, wills are testamentary dispositions made by a living person to come into effect at his death. I have with me Prince Uzeme, a legal practitioner based in Nigeria, and he's our guest today. Hello, and welcome to the Courthouse.
Thank you very much.
So, wills. I made a definition. I don't know if you have something to add, something to subtract, or your general perception or definition of wills.
Okay, wills generally, they are documents, like you said, that a person that we call a testator puts into effect. The document basically says that my estate, that's the testator's estate, referring to his property, whether landed property or personal property, that my property, I want it to be administered or divided in this certain way after I die. So the testator makes this document appointing somebody that we call the executor of the will, appointing the executor of the will to manage or administer his estate in a certain way for the benefit of others that we refer to as the beneficiaries. So in a will, we have the testator, who is the primary person making the document. We have the estate. The estate is a property. That the testator wishes to divide or make plans for. Then we have the executor. The executor is the person that the testator is given the power to handle his affairs after the death of the testator. And the whole purpose of making the will is for the beneficiaries to make sure that the wishes of the testator pass on to the beneficiaries after the death of the testator.
Okay, so generally, wills in this part of the world, some people say, if I'm making a will, it means that you are wishing me dead. Is that true? Is that what, in practice, people get to hear a lot?
Superstition has played a big role in the way we order our affairs, both our affairs while living and our affairs after the death of the person. Generally, people in Africa and in other parts of the world tend to believe that by them making a will, what they've done is that they are simply signing a death warrant to say that, oh, I'm about to die soon. That is why I am making a will. And that has given rise to the practice where younger persons or middle-aged persons never almost never make wills because they believe that I am not old enough to make wills.
So
They believe that
brings me to the question of when do I make a will? How? When?
A will is supposed to be made at any time in a person's adult life.
Okay.
What that means is that once a person attains the age of 18 and that person has property or possession that he could rightfully say this or that belongs to me, that person is entitled to make a will. Now, what a will does is that a will tidies up your affairs,
Okay.
even when you are no longer here. So, a situation where the landowner or the deceased person dies, and you see so much squabbles within the family, that things that tear the family apart, can be traced to the simple fact that the deceased did not put his affairs in order before he passed on. So a will is not for old people or to say that, oh, I'm about signing my death warrant. It should be a situation that learned persons, educated persons, should be able to put their affairs in order from time to time. And, you know, a will is not something that cannot be amended. If at any point in time you feel that the will that you made the other time is your mind is no more in that direction, you can always alter your will.
Okay, so you can always alter your will. Then that brings us to types. Are there types of wills, or we just have will simpliciter?
There are actually different kinds of wills, different types of wills. And it all depends on jurisdiction to jurisdiction. Okay. For every jurisdiction in this world, they have there are different recognitions of the will types that we have in practice. But generally, some types that cut across jurisdictions are, first of all, you talk about the oral will. The oral will in some jurisdictions, they call it the holographic will. Okay. It's a will that is made by word of mouth. And that is also a valid will. Now, the only defect to the oral will is that it is a will that is very difficult to prove. Because after the passing of the testator, the person that made the will, it is very difficult for the beneficiaries to that will to prove what exactly he said because of the unstable nature of oral communication. So that is one type of will. Then we have other types of wills. We have a prenuptial will, for example. A prenuptial will is a will that people a couple that are intending to get married, they make it before the marriage, okay, in case of the passing of any of them. So that's a prenuptial will. We also have what we also refer to as a mutual will. A mutual will is where two people come together and they make a will, a document, a testament that affects the rights and liabilities of both of them, depending on who passes first. Okay. So that is a mutual will. Then we also have the last one that in this part of the world we refer to as a codicil. The codicil in some jurisdictions is a will on its own. Okay. Yes, in some jurisdictions a codicil can be both a will and a codicil, but in other jurisdictions the will and the codicil are separate in the sense that the will is a primary document while the codicil is a document with which you seek to amend the provisions or what you've already written down in the will. Okay. Now, for a will to be valid, it is not every document that the person passing or the deceased person, it's not every document that he makes that can become a valid will. So there are certain yardsticks, there are certain preconditions that a will needs to meet before you can say that this is a valid will. Okay. In this part of the world, there's a requirement that the will must be in writing. This is a bit contrary to what I said about holographic wills, which are oral wills. So it is in writing, one. Then the testator, the person making the will, must be clearly named in the document. The property that the testator is seeking to apportion, either between or among his beneficiaries must be clearly stated and described. For example, it is not enough to say that a house lying in Toyin Street. You must give a proper address of the house. My house lying at number 13, Toyin Street, covered by this or that, proper address. Then the beneficiaries to that will must also be clearly named. It is not enough to say that this will is for just a general block of people. Even if for a general block of people, you must name the beneficiaries clearly. So beneficiaries must be named in the will for the will to be valid. And also, the will must have been made by the testator when he was of sound mind. So where a person is either going senile, or it can be proven that the person was not in charge of his full faculties at the time he sat down to make this will, that will is a voidable will. It's a will that can be rendered invalid when it is challenged in a court of law. Then lastly, a will must have witnesses. What that means is that you can't just sit down with your lawyer or with anybody and just make a will. The will must have at least 2 witnesses. At least 2 witnesses. It is a practice that a beneficiary in a will cannot also be a witness to that will. What happens generally is that where someone who is a beneficiary in that will is also a witness in that will, it means that he loses whatever has been given to him as a beneficiary, just because he's a witness. But the way the courts have gone around this is that to protect the validity of that will, where the witnesses are up to 3, one of the witnesses is also a beneficiary, the witnessing of that person would be rendered invalid by the court, and the other 2 witnesses would not be validated. So that protects the will, but for the interest of the witness who is also the beneficiary, he loses whatever was apportioned to him in that way.
I was going to cut you, but I just wanted to land safely on that point. We'll continue on that point, but I want to go on a very quick break and take a look at some of our legal nuggets and our report. We'll be right back.
A will is defined as a document by which a person called the testator appoints executors to administer his estate, that is, his assets and properties after his death, and directs the manner in which it is to be distributed to the beneficiaries, that is, the people who are to benefit from the will, such as family and friends. An executor is the person appointed or nominated by the maker of a will to administer or manage his estate after his death. He is responsible for ensuring that any debts and creditors that the deceased have are paid off, and that any remaining money or property is distributed according to the wishes of the deceased. Every will must have certain characteristics for it to be valid. If a will is not valid, it will not be legally binding after the death of the maker of the will, that is, the testator. The following are some of the characteristics of a will. 1. It must be made voluntarily. 2. The testator must be of sound mind. 3. It must name the beneficiary or beneficiaries. It must be in the presence of witnesses or a witness. And 5. It must identify the property. There are different types of wills, such as oral will. This will can be made orally before 2 or more credible witnesses. Mutual will. This is where 2 or more persons execute the same will, conferring mutual benefits or reciprocal benefits on each other. Prenuptial will. This is a will made by any of the spouses before marriage. Conditional will. This is a will that is executed by a testator and made subject to a condition. There are many advantages of making a will. It is important and a smart choice to make a will so that the maker of the will can protect his family, relatives, friends, and any other person he may wish to inherit his assets.
You're welcome back. This is still the courthouse, and we're talking about wills and codicils. And our legal guest for today, our panelist, is Uzeme, Prince Uzeme, a legal practitioner based in Nigeria, and he's been talking about wills, types of wills, the making of wills, whether this is valid or not. And he also gave us some inside advice as to the time of making a will. So you can make a will at any time as far as you are an adult. And Prince Uzeme, you were talking about a witness, also mentioned in a will that the person will probably not be able to benefit from that will. Can you expatiate on that?
Yeah, what I stated was that a witness to a will cannot also, at the same time, be a beneficiary to that will. So, for example, if the testator made to say, a statement that says that to my son, John, I give my property at so-and-so location. Okay. And John, the same John, now at the bottom of the will, now appends the signature as a witness to that will. What that has done is that automatically it invalidates whatever was given, that house that was, or whatever, that was given to John in the body of the will. The fact that he witnessed has invalidated that. Okay. Now, ordinarily, like I stated, that will should have been rendered invalid. Where there are only two witnesses to that will, and one of those witnesses is John, automatically that will is void. Oh. It is no longer a valid will. But where there are more than two witnesses, John's signature would be invalidated, and the other two or three, whatever number it is, the other person's signatures would be validated, and that will still stand.
Okay, in that case, since John is no longer a witness, or his witnessing has been disregarded or invalidated, can he now benefit from that will, since there are other witnesses to the will?
No. The moment he signed, whether the will is upheld or not, what has been apportioned to him is invalidated by the mere fact that he signed that will. That is a very important point to note, because going forward, every person needs to make a will at some point or the other. I also want to state here that the estate of a deceased person is classified in two ways. It's either the person died testate or the person died intestate. Where a person dies testate, it means that the person died leaving a valid will behind. Where the person died intestate, it means that the person did not make a will, or whatever he called a will was not a valid will. Now, where a person dies testate, the person administering that estate, that person is called the executor of that estate. Where a person dies intestate, on the other hand, the person that the court will appoint to administer that estate is called the administrator of that estate. So, in the language of wills, the executor is different from the administrator, depending on whether the testator died testate or intestate. Then there is also another issue that I need to point out. In wills, generally, you see, this is my last will and testament. And questions have been asked that is a will different from a testament? In the old days, when the law was still in its developmental stage, lawyers use words together, two words together, yes, to clarify what exactly they were trying to say. Okay. So it's like saying breaking and entering, aiding and abetting. They all mean the same thing. Assault and yeah. So will and testament actually mean the same thing. The person could have said, this is my last will, or the person could have said, this is my last testament. Okay. Now, another issue is that why are they using last in the document? What that means is that the person could have made other wills, but immediately you say in the latest will that this is my last will and testament, it means that automatically it invalidates all the other, the earlier wills that you've made. Okay. So the will that is later in time, as long as it is valid, it actually takes precedence or invalidates any other will that came before it.
Oh, so does that mean that people writing wills for the first time should no longer use this is my last will, because every single document you see as a testament, as a will, you see this is my last will. So should we write next time, this is my latest will, or this is my second latest will?
Well, the issue is that my last will and testament has become the practice because it is assumed that at the point you are making that will, that is actually your last disposition. Okay. It is not intended that, oh, I'm going to make a will every year of my life, or I'll make this will first. 2 years later, I'll make another one. Any person that sits down to make a will, it is believed that that is actually his last disposition. That is actually the last statement that he is making. So later on, if he gets to amend it, either by a codicil or making a fresh will, he will still use the same language, that this is my last will and testament.
Even though you told us that from our adult age, from 18, we can make our wills. So
yes. And it should be encouraged. It should be encouraged.
That he has more life ahead.
Yes.
Very interesting.
We've had notable cases in the developing world where families were torn apart simply because the man, the deceased person who was wealthy in his life, did not leave a valid will behind. And that has led to so much family divisions and family quarrels. When you go to the courts, you see so many cases in courts that are about families where the deceased person did not leave a valid will behind. So it is very necessary for you to order your affairs properly.
When you are alive.
Yes, when you are alive. And it doesn't mean that making a will means signing your death warrant.
Quite interesting, but do you have any advice generally, any last words on this topic?
Yeah, what I would say is that for anybody out there who is going out to make a will, the first thing is that you understand the gravity or the seriousness of the document that you are making. A will is not a document that you make when you are not of total mind. What I'm trying to say is that if you are not minded to do it at that moment, please don't do it. Because by making a will, you are actually putting those coming after you in the positions that you've stated in the document. Now, also, to minimize arguments in a will. Generally, a will can be stored anywhere. You make a will either by yourself or with your lawyer. And the will could be stored in the office of your lawyer or in your house. But generally, to minimize legal cases, the practice is that you store the will at the probate section of the High Court in the state where you are making the will. The probate section is the section of the High Court that deals with wills, or that deals with the rights and liabilities of persons who are deceased. Then I also want to state lastly that no matter what a person has stated in his will, if the person is a creditor to some persons or to some organizations, for example, if the person giving John a house, let's say the house is worth 50 million naira, and you are a creditor up to 51 million naira. It means that automatically you've not given John anything because the creditors will take precedence over whatever is stated in the will. So when the will is being read, the people that the deceased person is owing, those people will have to take precedence over those that were named in the will. So debtors take precedence in the execution of a will. Wow. So the testator must be careful to ensure that what is actually given out to his loved ones are not properties or that would be encumbered by actions, by debt recovery actions.
That's a very, very important point, very valid, and it's a point that we must all note. Testators, clear your affairs, make sure you are not owing all your properties encumbered when you're making your will. That is indeed very salient. But, you know, we have another segment, the bar book. And the bar book, we share Latin maxims, legal jargons, you know, like you said, in the old days, lawyers like to play around with words, quid plantata solo solucidate, things that we say in simple English, we just try and make them sound very, very verbose. So I like that too. So, bar book, what is your favorite legal maxim or Latin maxim for the week?
Today I'll go with the one that says, amicus omnibus, amicus nemini. What that means is that a friend to all is a friend to none.
Okay, I don't want to bother repeating any of those things you said, but you get to find out more Latin maxims on our bar book segment. Well, that's much we can take this week on the Courthouse. We had a very interesting segment with Barrister Uzeme. Oh, I said barrister. It's no longer a proper way of describing lawyers. Anyway, so Prince Uzeme, I want to say thank you so much for making our time to be on the show this week.
My pleasure.
Okay. So if you want to reach us, we have numbers I'll be showing on your screen now. You can also reach us on our website on www.loverplus.org and send your comments, send your questions. We'll be having our question and answer segment with you very soon. So we'd like those questions to keep coming. I am Itohan Olomo Agbodo, and I say, don't just get mad, go get a lawyer. Bye for now.